So we have heard from George Floyd's family, and we have heard from Derek Chauvin and his. So now let's focus on the sentence and how Judge Cahill came to that decision. To do that tonight, we welcome our friend Mary Moriarty to the show. Mary, you followed this case from day one. What is your reaction to Judge Cahill's sentence of 22 and a half years?
It's not very surprising. I think most people were pretty sure that he would give Chauvin a sentence greater than what the guidelines called for. And according to our cases from the Supreme Court and Court of Appeals, even though the statutory maximum was 40 years, the maximum that Judge Cahill really could have given him was 30. So I think a lot of people thought he would get between 20, 25. So there was nothing surprising about that. There were a couple of surprises in that, as mentioned before, his mother did speak. And he said just a few words and as you've heard, said something a little cryptic as well.
Mm-hmm. Now, the state had asked, and Floyd's family had asked during the hearing today, they wanted 30 years, and of course the defense wanted no time. Is it just typical, Mary, that a judge goes in the middle?
No, and I wouldn't look at it that way. I think this might be a helpful way of looking at it. The defense asked for probation, so no prison time. The state asked for prison time. The judge gave him prison time. The defense then said, if you're going to give him prison time, then give him some time less than the guidelines, which is 10 years. The prosecution asked for 30 years, and Cahill came up with 22 and a half. So I would not say he came in the middle at all. Where he came in the middle was that the range for the guidelines were between 10 and 15 years, and that 12 and a half is right in the middle. And so when he announced that he was giving 10 years more than the guidelines, what he meant was from that mid-range. So that's where he got the 22 and a half. But if I'm the prosecution, I'm happy with the sentence. If I'm the defense, I'm not, because he didn't get probation and he did do substantially, or was given substantially more prison time than he asked for, which was less than 10 years.
And that leaves us to the defendant right now, Derek Chauvin. He offered his condolences to George Floyd's family, but he didn't apologize, but he offered condolences. And then he didn't say much else other than that other statement. Is that because he is still facing a trial in federal court that he can't say much?
Well, a person who's been convicted at trial is in a little bit of a difficult position, which is that if they want to maintain their right to appeal and not say anything that's prejudicial, and they have 2 federal pending indictments, they don't want to say anything that can be used against him. But there is space, and this is what judges do look for some insight into your actions, some expression of remorse or empathy for the person who died and their family. And I would go back to the pre-sentence investigation, because Judge Cahill read that. And if you watch the sentencing, you know that Judge Cahill had his order or his memo already written. So he knew what sentence he was going to give. And part of that was based on the pre-sentence investigation. The probation officer would have asked Chauvin about the offense. And sometimes people who have been convicted won't talk about the offense on the advice of their lawyer. But he, I think, missed an opportunity there to at least show some insight into what happened. It appears that he didn't talk about the offense. He talked about other things. And then the defense memo was what I would describe as being fairly defiant, and said that he was just doing what his training and experience told him to do. He had no idea he was committing a crime. And they actually said that the death itself was fairly quick, which was not at all what Judge Cahill said in his memo when he found particular cruelty to be one of the aggravating factors.
Okay. Yeah, and you had mentioned, so Judge Cahill kind of knew what he was going to do before he walked in this afternoon at 1:30. The big question a lot of people are asking online, asking me in email, is what does this all mean as we now face a federal trial for Derek Chauvin? He's in prison in Minnesota, 22 and a half year sentence. And then there's this federal issue. Let's say he's found guilty in a federal court, does he automatically go to federal prison, or how does that work?
Yeah, first I'd say that if he takes that to trial, he's looking at a much greater sentence in federal court than he would if he accepted a plea negotiation. And there is incentive on both sides to arrive at some type of negotiation. His time would be concurrent. He can do his time or can negotiate to do his time in federal prison where people would rather do their time. And as far as the federal government is concerned, they could save people from having to go through that trial, particularly the bystanders and the community. And they also do something in federal court, which we don't do in state court, which is they can make it a condition of a plea that you give up your right to appeal your federal sentence. And if they did that, then if he appeals the state sentence, and we expect that he will, it doesn't really matter what happens there. So there's certainly incentive on both sides to try to negotiate. And I suspect there are conversations going on. And we should probably be hearing, I would expect relatively soon, whether they are going to arrive at a negotiation there.
Yeah, so in many ways, this isn't over today. Mary Moriarty, we thank you for your time, as always, for being on the show.